I think the issue of burning the Quran is very interesting and full of problems legally and morally. In Britain, the notion that the law should not protect religious ideas from criticism or even ridicule was thought to be settled in 2008 when the blasphemy laws were abolished. But recent events suggest that a de facto blasphemy law may be creeping back into our legal system under the guise of public order offences. And the upcoming case of Hamit Chosun, who stands accused of religiously aggravated offences after burning the Quran outside the Turkish embassy in London, is a test case that the boundaries of free expression in Britain today are being compromised. When Chosun was filmed last week setting fire to a Quran outside the Turkish consulate in Rutland Gardens in Knightsbridge, his act, reportedly a protest against the present Turkish government, against President Erdogan, was met with immediate violence. He was attacked by a person called Musa Kadri, who appeared to slash at him with a knife. He was certainly apparently carrying a knife, and kicked him when he lay on the ground. There was another person who turned up on a Deliveroo bike who also went in for some kicking. And one might assume that law enforcement would prioritise the violent assault and the victim. Yet while Kadri faces charges of actual bodily harm and possession of an offensive weapon, Chosun himself has been charged with a religiously aggravated public order offence, which he's pleaded not guilty to. And his trial is set for May the 28th, so some time in the future. But this raises fundamental questions. When did Britain start prosecuting religious offences again? And have we subtly reintroduced blasphemy laws by stealth? At first glance, the authorities will claim there's no blasphemy law at play. Chosun is not charged with insulting Islam, but with causing harassment, alarm, or distress, an offence under the Public Order Act in 1986. And the test really is whether or not his act provoked public disorder, and it seems absolutely to have done that. The problem is that this broad and subjective law allows law enforcement to selectively police speech and actions. If offence to religion is a criminal matter, then public order law effectively functions as a blasphemy statute, only without using the word. If Chosun were to have burnt the Quran in a private location, and if that also occasioned public distress, would that also mean that he was at risk of an offence against the Public Order Act 1986? I'm inclined to think it might. And I know in this, I don't think the black belt barrister agrees with me. But I think this is a very woolly area of law. Consider a parallel. If someone burned the Bible, the Book of Mormon, or the Communist Manifesto outside the Vatican embassy, would they too be prosecuted? Would a secularist tearing up pages from the Old Testament outside the Israeli consulate face arrest? I suspect not. But then all of these religious texts that I've just cited hold a different value to their adherents than the text of the Quran. The selective enforcement of public order allows a legal heckler's veto, or creates a legal heckler's veto, allowing those who take the strongest offence to dictate which ideas are criminalised. Now that, I think, is a worrying precedent. So in other words, the crime is not what you do, but whether or not people react to it. And what makes Chosun's case particularly significant is that it sits within a wider trend of growing legal sensitivity to religious speech, especially with respect to Islam. There's the Manchester case earlier this month, when a man in Manchester was convicted of a religiously aggravated public order offence for burning pages from the Quran while holding an Israeli flag, and he pleaded guilty and will be sentenced in April. The Starmer government is already considering a legal definition of Islamophobia that could criminalise some forms of criticism of Islam. and some worry that such moves will entrench a legal hierarchy of religions, with Islam being afforded special protection while other religions are not. British police forces maintain close relations with faith-based advocacy groups that frequently pressure authorities to take action on perceived blasphemy cases, and this raises concerns that police and prosecutors are not neutral arbiters but respond to political sensitivities. Robert Jenrick, the Shadow Justice Secretary, has warned that Chosun's case sets a dangerous precedent. He says, criminalising the burning of the Quran in any setting, if there happens to be someone in the vicinity who finds it offensive, creates a blasphemy law by the back door. And a blasphemy law which really only applies to one religion. If the courts uphold this prosecution, Britain may find itself on a slippery slope where criticism of religion is only tolerated as long as it doesn't cause distress to the most vocal and outraged. And this case also raises serious questions about Britain's commitment to freedom of expression under Article 10 of the European Convention on Human Rights. In past rulings, the ECHR has defended offensive expression, recognising that political protest, including acts like book burning, are a fundamental right. In Gunduz versus Turkey in 2003, the court ruled that political speech enjoys strong protection even if it offends religious groups. And in Vajni versus Hungary, the ECHR affirmed that symbolic speech, such as burning objects, was a protected political expression. If Chosun's burning of the Quran was aimed at protesting over Turkish politics rather than inciting hostility against Muslims, his action should fall under the umbrella of political expression and therefore should be protected. The prosecution would have to prove not just that his act was offensive, but that it was unlawful incitement. And perhaps the most troubling aspect of this case is the apparent disparity in how violence and speech are treated. Chosun burned a book and is facing a serious criminal trial. His attacker allegedly, or apparently, at least on camera, assaulted him with a knife, and another attacker kicked him from a Deliveroo bike and doesn't seem to have been tracked down. And the knife holder was granted bail and is facing less serious charges. This makes very little sense. It echoes previous incidents where those who commit physical violence in response to perceived blasphemy often receive lenient treatment while the original speaker is pursued with full force. This is dangerous. It incentivizes the heckler's veto, or worse, the knife wielder's veto, whereby the greater the violent response, the more likely the authorities are to suppress the original expression. And a legal system that subtly encourages violence in response to offensive speech and violence dictates what is criminal is not a liberal democracy. If Chosun is convicted, therefore, the consequences will be profound: a de facto return to blasphemy laws, but with religious offence repackaged as a public order violation. It will be a chilling effect on free speech where people censor themselves for fear of prosecution, and it will be an incentive for selective enforcement, reinforcing the perception that certain religious beliefs enjoy greater legal protection than others. But if Chosun is acquitted, it will send a clear signal that Britain remains committed to the abolition of blasphemy laws, whether that's good or bad, that the right to criticise and even offend religion is protected under freedom of expression, that public order law should not be used as a tool for enforcing religious orthodoxy. All this said, I fundamentally object to the burning of books on principle. I also fundamentally object to actions which are designed to offend and are designed to be unkind, and this was. Ultimately, the case of Hamid Chosun is about much more than one man's protest. It's a test of whether Britain still values free expression, even when that expression is crude, controversial, or offensive, or even, dare I suggest, morally wrong. If the courts uphold his prosecution, we may find ourselves in a society where burning a book is more criminal than attacking a person who burnt it. If that is the case, Britain will have quietly reintroduced blasphemy laws without ever admitting it. And the trial is definitely something to watch. The outcome will determine whether Britain remains a free country or one where religious sensitivity has quietly overridden the right to dissent.